So good morning. Good morning, everyone, friends, colleagues, partners of the ACT project. I hope you had a nice evening yesterday. Don't forget that we have another one after the around 5:30 or something like that. So I would like to begin by welcoming you for the second day of our ACT Partnership Midterm Conference. This conference that you will remember was originally scheduled for March 2021 is intended, in fact, to highlight the progress made since the launch of our project. Yesterday I spoke of the students. A few words now on the researchers and partners. So this conference, as I said, was initially scheduled to coincide with the delivery of the Partnership Midterm Report. I am pleased to confirm, as some of you know, that the SHIRC evaluators who were tasked with assessing the progress of the research project at the end of this midterm have repeatedly noted that the project has exceeded the goals we set despite the pandemic. It is thanks to the commitment of the researchers affiliated to the project that we have been able to maintain a high level of scientific production and activity. The numbers clearly show that the project has outdone expectation in all categories. Since the beginning, we've been able to produce close to 1,000 deliverables, and this number continues to grow. 100 scientific papers, 100 book chapters, 10 books related to law, justice, and AI, and thank you to all of you, and bravo. I would like also to extend a special thank to my team leaders, Jane Bailey, Jackie Burkle, Fabien Angelina, and Tom Van Engers, with whom I've been working for more than 10 years. And they have always been there, always been supportive, and their scientific enthusiasm is contagious. As I noted yesterday at the opening presentation, this partnership is also made possible by student engagement, of course. A significant number of students are indeed involved in the partnership in a substantial way. Data collection, analysis, publication, knowledge mobilization activities, etc. Finally, but not lastly, of course, we must salute the importance of the national international partners and their intellectual and financial contribution that have made this project possible. We have therefore set up a very interesting program that will allow us, I hope, to discuss the progress of the multiple research projects conducted with the ACT project. We've got two keynote speakers. In a few minutes, my colleague, friend and team leader Jane Bailey from the University of Ottawa will introduce our first guest speaker, Professor Daniela Piana from the Université de Bologna. Tomorrow, Thursday, my colleague, team leader and old friend Fabien Angelina from McGill will introduce our second keynote speaker, Professor Joël Pinault from the School of Computer Science at McGill University, affiliated also with Facebook. And I would also like to underline our student panel, moderated by Professor Gloria Gonzalez of the Free University of Brussels, with contribution from a new generation of researchers, Camille Border, Sylvain Longuet, Margot Dejean, and Marco Tumeni. And of course, we have other panels with great speakers, and I take this opportunity to say thank you to all of them. I would like also to thank Professor Nicolas Vermeijs, who was a key organizer of this conference. Thank you, Nicolas. The ACT researchers have understood the formidable potential of AI and consequently the corresponding risk, especially in the justice sector. Lack of transparency, systemic bias, discrimination, disempowerment of communities, false positive, and privacy infringement are some of the risks that we will talk about during this conference. The use of algorithmic tools in the justice sector should be envisioned with greatest care. And on this point, the European Union proposed regulation states that the AI system in the administration of justice shall be considered high risk. And I think that the ACT community share this concern. But such use should not be prohibited, but we must simply ensure a priori that it will be consistent with the rights and principles of fundamental justice. Both government and private corporations must avoid acting like sorcerers' apprentices. Taking an historical perspective, François Jarige reminds us of the negotiated nature of technological change. We must not hamstring ourselves by adopting a binary approach that portrays the discussion that must precede the deployment of algorithmic tools as a sterile opposition of unconditional adversaries. we must argue that the conflict and controversies around technology can be apprehended as attempts to negotiate change while preserving ways of life and established skills, as well as advocating for simple, flexible technologies in contrast with the new machines, which may be seen as dangerous. Such dialectic seems necessary and is not an absolute rejection of algorithmic tools. On the contrary, it leads to a dialogue that is necessary to ensuring that the rights and interests of all are taken into account as they should be in our advanced democratic societies. We cannot reject this dialogue on the stereotypical pretext of innovation. As Jarij explains, history shows that euphoric discourse about technology as the solution to all our problems is not new. It is part of the historical fabric of Western society. Pierre Musso reminds us that industry is the new religion of the Western world since the Renaissance, and that it is the fiduciary structure that holds together the Western edifice. It is the industrial religion of modernity slowly formed since the 12th century in parallel with the state and the political religion. So, seeing history as the background of our work and our reflection allows us to put current technologies into context and better understand their integration in the fabric of human activities. This contextualization is not devoid of a critical approach, which enriches reflection and should ensure intelligent regulation of augmented intelligence. So today, and tomorrow, we'll have the opportunity to discuss without naivete, but with determination, the best ways to ensure a fair deployment of AI tools that respect people's rights and enable responsible and liberating empowerment. Empowerment for the communities to exercise their rights with dignity and effectiveness. And I'm sure that we have very meaningful discussion that will lead to a fruitful collaboration, contributing at our level to a better access to law and justice. And without ado, I'm asking Jane to present our first keynote speaker, Daniela. Thank you very much.
Hello, everyone. We're very fortunate today to have with us as our first keynote speaker for the event, Dr. Daniela Piana from the University of Bologna. Daniela, welcome, and thank you so much for being here. Daniela holds the chair of Political Science and Rituals and Performativity of Law and Justice in the Digital Age at the University of Bologna, and is a permanent invited scholar at the ENS University Paris-Saclay. She coordinates the UNITWIN/UNESCO Governance and Citizenship in the Digital Age, and has founded, together with the University of Paris-Saclay, Maison des Intelligences Sociales et Numériques, and co-founded with the foundation of Paris-Saclay, WEH, World Educational Heritage. An interdisciplinary scholar with a strong interest in the interplay between actorness and normativity for more than 2 decades. She works on the quality of justice and people empowerment from a comparative perspective. She serves as a member of the OECD Justice Advisory Committee and as a member of the Scientific Committee of the Italian Council of the State. Among her most recent publications, Legal Services and Digital Infrastructures by Routledge in 2021, and Rules for Trust by Carocci in 2022. Dr. Piana's discussion today is entitled Beyond Access, and I can't wait to hear more about that provocative title. So welcome, Daniela.
Well, first of all, a very warm and not formal thank to Karim, to all of you, and to Jane for having me here and this Very nice introduction. I must say that from the point of view of someone who has tried to build a fully fledged research agenda from an interdisciplinary point of view, being here discussing with you about the interplay between the artificial intelligence, justice and law, and people empowerment, because that is in the title of the conference, is really a big opportunity. It is absolutely unique. And this unicity is also related to the fact that after the pandemic, we do have an enormous amount of experiences and knowledge that today is there, and we must make the best out of it in order to empower both people who are litigants, but not only litigants, and people that are staffing the legal and justice institutions. So I have decided to entitle my talk today in a quite provocative manner, but I immediately want to say that my proposal is not to take access to justice and to throw it away. The idea is quite the opposite. The idea is to place access to justice into a broader perspective. So I really liked this notion of put it in context and also having in mind the historical, path that is beyond us, but not so far. So I think that that's the right way to observe access to justice. Let me start with something that is a little bit poetic. In a forest of 100,000 trees, no two lives are alike, and no two journeys along the same path are alike. So if you read this in a very superficial manner, you may think that the idea of equality is something that cannot work in the legal and justice sector. My point is exactly the opposite. And I think that once we take seriously the relationship that exists between access as a value that is promoted internationally in the legal and justice system and by the international organizations, and equalities at plural, we have a broad both research and policy agenda that is just waiting for us to get in and to take it seriously. Now, what we are going to do today? In my talk, this is the outline. What I want to do is to go a little bit back in time and to reframe the importance of the access to justice as a main value promoted by the international organizations and also national organizations in relationship to the idea of equality. Secondly, I would highlight the way technology, and especially this combination between digital technology and data, which is something more specific than technology broadly meant, has tried to be used to improve and to deepen this capacity that we have to ensure equality via access to justice. Then I will raise some, I would not say concerns, some remarks that are evidence-based. We have research, empirical evidence, data and empirical evidence from qualitative research that testify the fact that we do need to rethink and presumably to revitalize this nexus between access to justice plus the digital transformation and the equality, guarantee. And then I have some proposals, and the proposals are touching both sides in the legal and justice sector. Both sides because we have to, I think that we need to empower both citizens and and the staff court and the legal professionals. So people that are really interacting with technology and artificial intelligence. So I think that in this way I regain some of the topics and the issues that have been addressed yesterday in this marvelous opening that I have really appreciated, because I think that for tomorrow we were speaking about the future. Well, in the future I think that the intelligence is plural, so we need many voices to converge on the same topic. Okay, so why access to justice? Access to justice basically is something that has been progressively gained the top priority place in the international agenda. First, because everyone recognized that even though equality before the law is something, that is absolutely pivotal, but is not enough. It is a necessary condition, but is not sufficient to ensure that you have equality. More than that, quality of justice, which is a topic that we know very well, is related not only to the quality of the procedures and the proceedings from the legal point of view, but also to other things. The next step, if we go back to history, not very far, but anyway, 20 years ago, more or less, or 25, is to go beyond the idea of the procedure and to relate the equality to the fact that you have an efficient justice system. An efficient justice system is useful, is necessary, because you need to ensure that people, regardless of the social and economic situation in which they are living, they are capable to afford the cost of waiting that finally they will get a response from the justice or legal system. So technology first has been thought as a way to medicate inefficiencies and the overload of the courts, and there you have all this nice and marvelous stream of policies and indicators and policy narratives that are all focusing the efficiency, the court management, the file, management, and so on and so forth. And once again, underneath, equality is always there. The idea that you protect better equality if you have a more efficient system. But this was patently not enough, once again. So in the more recent history, we have a third step, and this third step is about the equality of access. And the equality of access is more than simply the fact that you have an efficient system. It's not only related to a high quality time frame in the trial. Equality of access is something that is related to the capacity of different people coming from different social and cultural contexts to be empowered to access the legal and justice system. The three steps are quite significant because, of course, they are all related to a sort of an extension of the notion of equality, which is not only the formal equality, very much related to the notion of the rule of law, as we know, but also to the idea of equality in terms of affordability, of the cost of life and the cost to access to justice that for many people are not affordable at all. And finally, the fact that you want to have equality of opportunity, which in the moral philosophy and political philosophy goes back directly to, Ronald Dworkin and all these type of works. Now, of course, this has been something that happened both in the research and in the policy agenda worldwide. And it has been a quite glorious ride, hopefully, because in the end, what we managed to have is from, over the last 10 years, there has been a high level of attention devoted to the budgeting that are allocated in each country, for instance, on legal aid. just a small indicator, but this has been quite emphasized. For instance, if you take the report published by the Council of Europe, and I know that is not, covering all the countries in the world, but it's just to give you an idea that there is a political engagement, because you basically encourage the national governments to measure and to monitor and to compare, legal aid budgeting. More than this, over the last decades, there is also the fact that this idea of access to justice has been the focus of new projects. Think about, for instance, the World Justice Project and all what has been done by the OECD, which is not anyway an organization, an international organization whose main mission is on the rule of law, but nevertheless access to justice has become one main point on the agenda. Why that? Of course, because if you wanted to have small and medium enterprises that are capable to afford the time and the cost of a legal and justice system, you need to focus on access to justice. And definitely we managed to have, all a set of tools to measure the gaps between, the demand of justice and the access to justice, and on the other side, the capacity for countries to learn in a horizontal manner, the one from the other, about what they are doing in access to justice. Once again, I think that it is extraordinary, the development that we observe in terms of alternative dispute resolution and online dispute resolution, related to the idea that you improve by this way the access to justice. And finally, there is also this idea that the litigation can be settled in a way that is not necessarily centered on the state. So there is a sort of an extension of both partnership, private, public, but also the actors and the stakeholders that are there in an arena, which is an international multi-level policy arena, where you have many people that, are animating it. And these are what we, the things that we gained, because access to justice played really as a sort of a path-breaking wording. Path-breaking because we started really to observe the legal and justice system from another point of view, which is the point of view of the demand of justice. And I wanted to highlight this point because this is very important. For many years, justice has been a key topic on the international agenda. It dates back to the 70s in the 20th century that we started with the international organizations, both governmental and non-governmental, to promote better justice. But it was really devoted to the idea that you made a better court system. So it was on the side of the offer. The demand was a little bit, sort of a minor topic. For many reasons, I don't want to go into the details of this. And of course, this has also allowed us to gain new knowledge, something that we didn't know before, about what happens before you get into the legal and justice system. Because here the point is absolutely crucial and essential. If we take seriously the nexus between access to justice and equality, the emphasis must be on the equality. The legal and justice systems are there because they must be there to serve the protection of rights of citizens, the citizens of today and the citizens of tomorrow. That's what, the law is about, to be, capable to last. So now it is quite difficult to have data, or it was quite difficult to have data about this sort of a, pre-legal justice system step, which is a way to say that we didn't have data about the problems experienced by people. If you meet someone in the street and you ask this person, if she or he has legal problems, maybe the person will tell you, absolutely, I don't. because they do not represent the problems that they have in legal terms. That's, the job, the cup of tea of legal professionals. Lay people simply have problems, many problems, and most of the time they do not know that these problems do have a legal dimension. Imagine if they can imagine that they have also judicial dimension. It's absolutely something that can come out of the blue for them if someone reveals this magnificent secret that belongs to an expertise that lay people do not have, and maybe they do not, they cannot have, and it would be unfair to ask them to have. So I think that when we started also with this pilot experiment, which was the Legal Needs Survey, launched by the OECD and then the World Justice Project, just as an example, I think that once again we started. It is not the end. It was nice to have an idea about what happens before that people understand that they need to, address their life problems to the law and the justice institutions. Now, exactly here, technology comes in. And technology comes in because there is a huge and also a very inspiring promise within technology. If we wanted to have a better access to justice in order to ensure that you have a higher level of equality, technology may be seen as, a potential answer. In which way? First, because with technology you can unlock the barriers that are in between the demand of a problem solution, not justice, a solution of a life problem, and the legal and the justice institutions. Technology may help. Yesterday we saw examples. The fact that you may translate in a lay discourse, in the natural language, legal categories that are very complicated. Imagine what happens in the European Union, where the same kind of social phenomenological behavior can be labeled with different legal concepts and categories because we have many national systems. And of course, the fact that we have the EU law doesn't give a response to the fact that you have a substratum, a semantic substratum that makes sense to everyone, in many different communities for the same thing that I call social legal, entity. But this is just one point. I think that there are more things. Secondly, technology has been used to extract, to infer the potential knowledge that there is within the data in order to empower whom? Empower both sides of the system. The people, the lay people, because we noticed that you may have from big data something that is considered as a friendly, accessible knowledge for people. This is something that was not possible 30 years ago. And it is not a technology that makes the difference here. It's the data and the fact that you have the digital representation and the dematerialization. Is this the point? And on the other side, the same holds on the side of the author. The legal professionals, the staff within the court, are expected to be empowered because they can use this, knowledge in order to improve their decision. And finally, there is also something in terms of communication, because we understood that one of the main barriers, this barrier between, the person and the system that may give an answer to the problem of life that she is experiencing, are barriers represented by communicative, I will not say bias, because they are not bias. Communication is simply an interaction. If you interact with someone that you do not know, it is quite possible that you simply do not get the point that the person is expecting from you. And of course, we cannot imagine that the justice institutions communicate with each citizen in a personalized manner, because this is absolutely utopia. So the idea that you can use technology and artificial intelligence in order to build, for instance, legal design-based tools, that's something that goes in the direction of being, more communicative, which is back related to this idea of filling the gap in terms of access to justice, gap in the access to justice. So now, of course, data matters a lot, and data are very welcome in this new world that we try to build together. Why? Because in many ways, data technology and the needs to improve the legal and justice system met in a moment where we did get the awareness that there is a gap. If it were happening 30 years ago, it was, in a way, not in the right moment, I would say. Now we know that there is a gap. And there is a gap that relates to the knowledge we use. There is something very cognitive at the basis of this. And data are there, and they are used in order to improve what in the end? The intelligence of what I love to call the intelligence of the trial. When in the justice system, you have many types of intelligence that are operating. Okay, we have the artificial intelligence, but there are also the intelligence of people. There are the intelligence of the organization. If you enter a court and you observe how people are behaving, many things that are happening, they are not verbalized. Hopefully, because otherwise they would not work. So in the end, but this is an intelligence, a type of intelligence. And you have also the sort of ethical intelligence. People do know and do feel what is acceptable for their professional group of reference. And this is something that is, once again, a form of intelligence. So, in a way, data are considered as a very nice way to channel a new empowerment for the intelligence. And there is also this potential of democratizing this new thing that is coming, because it is more easily, more accessible, or more friendly accessible. And here we have our keyword. What does technology, in fact, structurally and cognitively speaking? Technology is getting into the legal and justice systems, or I would love to say institutions generally, multi-level, through the channel or through the mechanism of standardization. And that's something that creates a link between the equality of access and the way the legal and justice institution function. Think about the fact that when you build your justice boat, you imagine that you have a category. The tenant is a category. Within this category, all the instances token of tenants are put in. That's the way concepts work, hopefully. That's the way we have, we wanted to have concepts with us. But there is a standardization inside this. You have in mind implicitly that in the category you can have an equal treatment of the needs of those people that are individuals that are within the category. And the same applies when you think about a platform, an interface between the person and, the system of contents that is the intranet or cloud, whatever. You get in, there is a sort of a menu, There are, things that you can do and things that you cannot do. And the behaviors are standardized. But there is also one point even more important in terms of standardization. And this is due to the fact that when you build algorithms, there is no other way. When you build the feature engineering side of an algorithm, you need to standardize and to categorize, the type of features that for you are important in order to have this algorithm, or you do not have this algorithm, you have this machine learning on this data set. So these steps are necessary. They are healthy. They are part of, this encounter, which is a very fruitful encounter between a technology, artificial intelligence, sophisticated mathematics applied to data, and the world of law and justice. I do not have anything against. I'm very in favor. That's my point. And that's the reason I decided to entitle my speech in terms of access, beyond access. Because the point here is the following. The entire, focus is, I think, on the choices that we make in terms of which categories, with which kind of intra-categorial equality that we consider salient, significant for what we are doing. Maybe if you have, a set of tenants, just to give you an example, because yesterday we have this example, I made other examples in my talk, but this is very fresh in our memory. Imagine that you have this, sample of people, and you have another sample of people that are non-tenants, right? So the concept of tenant split into the society. But you may find other categories that are salient and that they are simply, cross-setting the two sample, right? Fine. Who decides? Okay, that's the point. Now, it's true that so far I have highlighted what we gained. We gained from this, ride made by the notion of access, and we gained from this encounter very, very important and productive between access to justice, technology, and data. But still, there are few things that we need to focus. And empirical research is telling us that there are more things that we need to take into account. First, we know that despite the fact that we have developed so far many tools, many ways to improve, this interaction between lay people and the legal and justice system, there are still, evidence that once you have got in, the people that are there do not experience entirely the solution of the problem. More, we do have evidence, and this is something that relates, for instance, to, the experience of consumers demanding for a dispute settlement, who in the end do not feel happy entirely about the way, despite the easiness of online dispute resolution mechanism, they feel that they do not experience a fully satisfying, kind of response. More, we know that from a comparative project that we have just, released, many people, despite the fact that in countries the recent reforms targeted the technological endowment of courts and legal institutions. Despite this, there is not a linear correlation between the increase of trust and the increase of budgeting on ICT courts. So, this seems to be sort of an evidence that opens a sort of a question mark. Here I wanted just to give you some numbers. Of course, the selection of the countries is, just to give you the idea. The third column is the more interesting for us. These are data from the Global Access to Justice Insight, which is a focus, a sort of a program launched by the World Justice Project. And they collect data about, all the path from the start, where a person is asking for a response from the legal and justice system, toward the end. And I think that what is interesting is the third, column that you have there, hardship experience during the period of time where the person is interacting with the legal and justice institution. And I think that the interesting point of this column is that you have a high level of, percentage, despite the fact that countries are not, homogeneous. You have high-income countries, poor countries. You have many, counterintuitive data here. So I think that from this we can just infer, not that online dispute resolution or alternative dispute resolution or chatbot, they are not a good thing. Absolutely the opposite. I think that we need to have a better understanding of this interaction and to take seriously the word interaction. Because so far, from the empirical point of view, we stopped on the access to justice in the in the simple sense of the word, access to justice. I'm not saying access to the door. I know that we have data, that are focusing on what happens beyond the door, but that's not the point. If we take seriously the idea that there is an interaction, then the interaction is something that must be observed empirically. And here we see that there isn't an interaction. And the second column tells us that the problem at the end of the path is still there in, half of the situations. So that's something for us. Is important because if we wanted to speak about empowerment, people empowering, and something that is not a discrimination, we needed to understand what's going on there. There are only macro data. Okay. So now, I think that we need an alternative response to this problem that we have. And it is a problem both from the research point of view, but also from the institutional and political point of view. Because if we speak about equality and the decisions concerning which equalities related to what matter, this is a decision that is a political decision. As all decisions, by the way. A decision is the exercise of power. I think that we may agree on this. Okay, so I think that now I can propose you a few things. First, I told you at the beginning that in my understanding, the problem that we have had, or let's speak not about a problem, I think that it is a huge opportunity. And I would word this opportunity in terms of revitalizing, really, the agreement, the social contract that exist between people and law and justice institutions. But when I say revitalizing, I think that people must be really put at the center of our, new horizon. And when I say people, I mean both people. People from the side of the demand and people on the side of the offer. Also legal professionals, judges, prosecutors, notaries, lawyers. Because this, long journey that we have done has left a lot of positive things, but also has created a sort of a vertige, a sort of a malaise within the legal professional groups, because they feel that there is a tension between this standardized way of doing things and producing responses and the way they are exercising their professionality. And for them it's important. It's a matter of identity. It's something serious. They don't want to give up. And maybe they are right. The point is that we have to encourage them to be inside the process of the design and also the observation of this new, sort of a new partnership between the side of the technology, the side of the law, and the side of the professionalism, which is multiple, by the way. And that's the reason I also highlight here. We have been speaking a lot about the demand, but I think that the side of offer is equally important. I tell you this because I rely on many data and empirical evidence collected through comparative research projects. And what I did is to go within the courts, observing which is the reaction of people when you really inject in the daily experience of work a chatbot, a technological tool, a new system, a platform, which may be hyper efficient. So from the point of view of your point of view, who has been the designer, the engineer, you feel that is fantastic. But for them, it's something that creates a sort of an uneasiness. More than this, when you have, I would say, artificial intelligence based tools supporting the decision-making processes of judges, the point is, which is a part of a broader world, the point is that most of the time they resituate themselves in terms of autonomy and independence. And I'm not sure that I can tell you that which side is empirically experienced. Sometimes they simply are happy to give up, but not to give up because they do not want to do the job, simply because they feel they are more secure, they are more, they rely on a solid basis. And it is understandable because there are, situations, countries, not only our countries, many countries in which judges experience very hard situations of working. So they may rely on something that is objective. On the other side, if you have cases or pilot experiences where the judge is simply, receiving the dossier with a number which indicates the probability to resolve this according to the average of the previously taken decisions on this topic, the point is that the judge is expected to judge. How do you do it? So you must justify the reason you take distance from this number, but this is a number, you do not know how the number has been produced. And maybe it is not the job of the judge to know, advanced mathematics. That's something that we cannot ask a judge. I don't want to have people that are, doing everything. I really do not like it. So I think that when we speak about empowerment and people empowering, we need to keep the two sides on our table. I have a few proposals. This is just to represent what I've said. So I like to say, you see, metaphors are nice, but this is the Italian soul that comes out. The dance of intelligence is a way to say that these different types of intelligence must be part of our agenda since the very beginning. That's the step forward in order to propose a new paradigm. And we need to have a fully shared awareness that people experience on the side of the demand and the side of the offer, uneven experience of the access. And this experience is a word that I have used many times because it is the experience that matters. I go on some proposals because this is just, okay. So now, first, let's put once again on the top of our thoughts the notion of equality, and let's broaden a little bit our perspective. I say, anytime that we standardize by using technology, by using mathematics, by using organization, the interface between the demand and the offer of something that touches directly a fundamental right, there is a hidden choice on which equality we promote. I give you an example. There are many examples in many countries of special services devoted to victims, special services devoted to women, special services devoted to linguistic minorities. Who decides? Why these differences or equalities come first? This is an institutional decision. I'm fine with that. We need to choose. There is no other way. But the point is that if this is a decision, then must be subjected to a number of mechanisms of accountability, as all decisions in a democratic world. Now, which then mechanism of accountability? I have a proposal. It's a very modest proposal. It doesn't make a revolution. Despite, the title, which is a little bit provocative, there is not any encouragement to make the revolution here. But the idea is that, given the fact that we make choices, we need to subject this matrix of intelligence, this nexus of technology, law and justice, and the society, to a recurrent method of revision, which engages since the very beginning the different voices of stakeholders that are representing the different forms of intelligence. So I give you a very practical example. It may be an observatory, a unit, an institution, an oversighting body, whatever, it doesn't matter the name. Each country may decide the way it organizes it, but the designers, the users on both sides, civil society plus the staff, the legal professionals, and a representative or an instance of the representative institutions that are democratically elected. Because this is something that relates and goes back to the rule of law, and to my understanding, the rule of law is something that is homogeneous in a country. So we need to have many tools differentiated on the basis of the needs, but each 2 years, 3 years, but recurrent. A way to go back to what we have decided to ensure, to protect, to promote in terms of filling the unequal, unfair gap. Because it may be that the society, you know, over time changed. It may be that we changed culturally. And I think it is the right of citizens to go back to, you know, to observe what happened with these decisions made. Are we happy? Once again, we confirm, fine. We need to have data, so the research is incorporated in this specific, you know, mechanism. And the last, okay, making accountable decisions. I think that this is a very, it is feasible, it is sustainable. We do have the bodies, we do have the awareness, and in the end, I think that the step forward must be done in terms of the narrative and the paradigm that we promote. Ruling out the option, you know, where you say, okay, either or. There is not either or. Artificial intelligence is with us. It is exactly by this that I came from my hotel here with Google Maps. No problem. But we all know the day in which we understand that our Google map is just driving us in the wrong direction, we know how to stop it, and we decide. And we feel responsible for this decision. If I stopped it and I would have been come later, it was on my responsibility, right? So, as far as this is something that matters for the life of people, I think that we need to relate immediately. Access to justice is related to the decision of which, you know, side we want to have on equality, because inequalities do exist. And it's from this point of view that would be able, you know, also us and the institutions to be very without naivete, to recognize that we have done choices and do not leave engineers to do choices simply by saying, okay, but this is the choice of the designer. No, too easy. It is our choice. Fine. The designer, the engineers, the mathematicians, they are highly, you know, high experts, but they are part of. Okay? So with this word of encouragement and engagement for the next maybe 10 years, I thank you very much for your patience and also for giving me this nice opportunity to be here.